ahead of time, but the clocks are different all around the building to keep us on our toes. Yes.
Please, my lords. Just before I move to law, forgive me, there were two references I should have given you that I had sort of promised during submissions. The first was a picture of sweeping.
Yes.
And it was in respect of sweeping photographed by HMFI in a document called TDN 35. There is a photograph, and this is within the.
Won't tell us where it's to be found.
It's in the long series of bundles from White, the library, at page 798.
79 how many?
798, my lord, please.
So that's bundle 2. Sounds that you don't have. Oh wait, do you have tabs?
I don't. I'm so sorry.
No, don't worry. We'll find it. It's just slower. Sorry.
PDF 798. Sorry. The page number.
I've got the page number 798. Just finding it with which tab it falls under. I've got it.
TBN 35.
So I'm hoping you can see there the left-hand side of a worker who's sweeping floor of asbestos factory with a broom.
Yes. Well, A, it's a bad photo, and B, I don't know. It just shows somebody creating a cloud of dust. You've no idea. That for all I know, there might have been a heap of white powder there, such as boundary. One just doesn't know. It depends how much stuff was there.
Precisely, but what it does show is the answer to the question, can we show that sweeping causes clouds of dust? The answer, yes. Here is a photograph of clouds of dust from sweepers.
I think I would have.
It's perhaps not central to the process, but
Okay, thank you.
I promised it.
Yep.
In terms of then the Red Road document that I referred to, this is at Supplementary Bundle 2, tab 7. First page.
Yes.
Tells you all the Ds. It's the report of an asbestos dust survey carried out in 1967 on some prefabricated buildings that were being constructed in the Red Road area of Glasgow. What the authors of that report sought to do was to compare various activities involving asbestos, including trimming of asbestos insulation board or fixing asbestos to girders, and then to try to set out descriptively what levels of exposure appeared to pertain to them. And if I could just turn then to page 24 to introduce the table that you can see there, and it sets out various activities and the descriptors. You can see to the right-hand side, well above the acceptable level, above the acceptable level. And then if you turn the page over, my lords, I hope we'll see page 25 now, the penultimate reference in the table. Sweeping up waste material, taking place with poor natural ventilation with undamped waste, very much above the acceptable level. It's the only activity that has that descriptor. And then at page 27...
Where's the acceptable level defined?
It's not. It's one of the weaknesses of this document that it's a relative exercise. And that's why I've concentrated on the descriptors. It's the only one that says very much above the acceptable level. But the conclusion, you can see, my lord, I hope at the top of page 27. First couple of sentences should suffice. By far the dustiest operation and the one involving the most risk to health is the sweeping up of the dry asbestos waste. If possible, this should take place in a portable industrial vacuum cleaner in preference to a brush. And the waste should be thoroughly dampened beforehand. And it also then refers to respirators. But the point is that even amongst candidates such as mechanically soaring asbestos insulation board, sweeping was considered the dustiest operation.
So, did you say that there's no, not only is there no definition, but there's no quantitative results?
No.
Is that because they're in an appendix which we don't have?
No, I don't believe it was ever attempted again, where it's a point in time before counting of fibres was mechanically undertaken. I think.
There are some results.
So,
Yes. It's in the expert report.
give me 1 second. I'm going to
Okay. Supplementary bundle 1, page 139. Sorry, 137. What happened was that the claimant's expert had the Red Road survey, and in fact, apparently, I've been told there was some supplementary material that she obviously referred to, and she reproduces it on page 137 of supplementary bundle 1, which is a table
In Cuthbert.
in Cuthbert.
very grateful to
There's
her.
Miss Conroy. Look,
In Cuthbert.
Yeah.
Yeah, Miss Conroy. Yes.
Page?
137 of the bundle, and it's the right-hand column with some results. Apparently, it came from separate part of the report. It's not in the bundle.
Sorry. Well, I'm grateful to my friend.
hold on 1 second. Yes, I see. I see the figure is 37. Yes, she doesn't say where she gets it from, but I'm sure she didn't make it up. So
No. In one sense, it doesn't really take matters
No.
forward.
no,
because
your
it-
point is simply it shows that sweeping up dust is produces an awful lot of
Yes. But I'm grateful.
inhalable dust.
So with that then completed, if I can then turn as swiftly as I may to the authorities.
Yes.
We break them into 2 parts. There are the framework negligence authorities, which we can deal with really very quickly, with 5 swift points to be made, and thereafter turn to the asbestos authorities. And could I please identify the first case that we rely upon is the wagon mound, which isn't in the bundle itself, but is cited sufficiently in the judgment of Lord Justice Akins in the case of Williams and the University of Birmingham, and that is to be found in the 3rd volume of the authorities, divider 23. My Lord, I hope will forgive me not giving full citation of authorities unless it's required.
No, don't worry.
Williams and Birmingham.
Yep.
Obliged. It's page 931.
93.
931, please. Paragraph 34. And there the learned Lord Justice, dealing with the degree of foreseeability of risk of injury or harm necessary to establish a breach of duty, sets out Lord Reed's dictum in the wagon mound. A person must be regarded as negligent if he does not take steps to eliminate a risk which he knows or ought to know is a real risk and not a mere possibility, which would never influence the mind of a reasonable man. What the case of Bolton and Stone did was to recognise and give effect to the qualification that it is justifiable not to take steps to eliminate a real risk if it is small, and if the circumstances are such that a reasonable man, careful of the safety of his neighbour, would think it right to neglect it. And the point that we make here, of course, is that where the outcome is as serious as asbestosis could be, it would be a very small risk indeed that a prudent employer, given the duties that they owe, could think it right to neglect it. And the second authority then, in terms of framework, we would seek to rely upon is Kufos and Charnikov.
Parent 2.
Yes, that is tab 2. And there are two brief citations. The first is from Lord Reed.
Oh, sorry, which tab did you say?
Sorry, tab 2, my lord.
It's not tab 2, which is...
Oh, tab 5. Tab 5. Forgive me.
Yeah.
I'm so sorry. I heard myself slightly.
You excuse me a moment. You couldn't hear it, but my phone was going off in my ear.
If we could turn, please, and of course this authority, I should say, is nothing to do with personal injury at all. It's actually a dispute around a charter party, but the lordships had to consider the difference between the test of what was in the reasonable contemplation of the parties for the contract and the reasonable
It's
foreseeability.
all law school stuff. Where's the passage you want?
144, please.
148.
144. My lord, it is trite. This is page G. Sorry, forgive me, letter G. But turning over the page to 145, the reasoning for the trite law is of importance to us. And it starts 6 lines down, but in tort. There is no opportunity for the injured party to protect himself in that way, that is by the contractual bargain and the limitation of the bargain. And the tortfeasor cannot reasonably complain if he has to pay for some very unusual but nevertheless foreseeable damage, which results from his wrongdoing. And it was this passage I had in mind when I was submitting this morning, that one of the reasons why there is such an all-enveloping duty on employers is the level of control.
But this is about remoteness, not about duty, isn't it?
No, it is about remoteness, but it's the underpinning of remoteness leading to you are responsible for a very wide and unusual set of circumstances. But why that is so is relevant also to the scope of the duty of care. And it lies in this imbalance that the victim of a tort usually does not consent to be a victim. The third judgment is that of Mr. Justice Swanwick in Stokes and GKN. The citation of law there, of course, is very well known. I just give it. It's at divider 4, again bundle 1, page 94, D to E. And this, of course, is the passage that deals with how an employer is supposed to discharge the duty of care that he owes, and it draws a distinction between recognised and general practice, which has been followed for a substantial period in similar circumstances without mishap, which he's entitled to rely
Well,
on.
there's no need to read it all out, whereas it's very familiar. Is there some particular point you want us to draw from it?
No, simply to give you the citation there.
Yes, okay, well, you've done that.
Thank you. But then at the bottom of page 99 is a less well-known citation under the letter H. And my lord will recall that before the short adjournment, I pointed out that ministry inaction might not necessarily be sufficient to prevent breach of a foreseeable, given the creation of a foreseeable risk, that it was then breached by doing nothing in respect of, by the citation in respect of the failure by HMFI to give warning as to cancer as opposed to dermatitis, and that was the basis for the submission. It's at the bottom of page 99.
Yeah.
Thompson is the fourth of the 5 authorities, and that is at divider 6. It commences at page 189, but the citation that is often used is at 199 and 200, dealing with developing knowledge. But again, there is a second part that I do respectfully draw to the court's attention as well, at page 205 of the bundle, page 421 of the authority, where Mr. Justice Mustill set out that the HMFI had done little in respect of deafness, which was the disease under consideration in that case, despite having known for a period of time about its dangers. And then referred at letter C to a code of practice from 1972 in which the HMFI produced something of an apologia, saying that the solution to the problem was a complex one, had been hampered by ignorance rather than.
Yeah, well, we can see what it said, and we can see what he said about that in the passage that followed. Is that what you wanted to read?
Was,
D
thank you.
to F. Yeah.
And then finally, in terms of the preparatories, Paris and Stepney, which is the second divider. I will recall this is the case of the one-eyed employee who wasn't supplied with goggles and lost the sight when a piece of metal that was produced struck his eye.
42.
Yeah. And it's Lord MacDermott. At the bottom of page 64. Who says about the duty to take reasonable care is directed to welfare, must be related both to the risk and the degree of the injury. So the outcome is important, the level of outcome should risk fructify into actual injury occur.
So, do you put your case like this? On the basis of the papers we looked at this morning, even modest exposure gave rise to a foreseeable risk of asbestosis because no one knew. And therefore, following cases like Jolly, you've got a foreseeable risk of one personal injury, and even if no one had any means of knowing of the risk from lighter exposure of mesothelioma, you get home on conventional principles. Is that how you're putting it?
Save for the intermediate step of we accept there has to be a higher level of exposure before the watershed than after the watershed in order to create that foreseeable risk of injury, and that the signal that that higher level is probably being breached is the creation of a visible cloud of dust. But yes, all other elements then fall into place.
Hang on 1 second.
Okay. We can make it shorter, can't we? Your case is that the levels of exposure evidenced in this case gave rise to a foreseeable risk of asbestosis.
Yes, because their peaks. Yes, because their peaks created the visible cloud. Yes, and but
That's your case.
yes, only in the forgive me, Miles. Only in the case of an employer and an employee. It wouldn't be the same if it was just an occupier or there was some neighbour duty. It's because of the employer-employee
Well, let's
relationship.
leave that for when you're appearing for a widow or a widower non-employed person. That would be unwise of us to go hard and fast on that in a case that doesn't arise.
Well, he was an employee, of course.
Exactly.
But
The question of the non-employed person doesn't arise.
no, it doesn't. Of course, it doesn't on the facts. But I am willing to concede the proposition that it might. What I am saying may not be good law if there isn't the relationship of employer-employee between the tortfeasor and the victim.
Even though the foreseeability is the same.
Yes, it's just that the duty nexus between the two parties is insufficient for the law to say, no, you must do something about this. So, silly example, if you are a plumber, you come into my house, you fix my pipes and expose yourself to asbestos that I didn't warn you about in 1955. That's a very different circumstance than if I'm the employer that sends you in knowing that there could well be asbestos on the pipes to do the same job.
Is Margerison still a controversial decision?
No, because the primary finding in Margerison was that the duty of care did not stop at the factory gates, and the evidence in that case was that the residents of Armley, who had the misfortune to be close to that factory, were substantially exposed. And you can follow that vein through to what was seen embarking around the cake factory. My Lord, in terms of the asbestos authorities, they commenced with Owen and IMI. What I propose to do, because of time constraint, is to again give a summary of what I'd say the evidence of exposure is and the references. The deceased in that case had been exposed from 1951 to 1976. The case had initially been put relying upon some very low levels of exposure. That is, he was working in the vicinity of lagged pipes, that he'd used asbestos gloves, and he had used, there'd been asbestos in the ceilings around him and in some hanging curtains, all of which had become abraded over time. All of that was effectively abandoned at trial, and at trial, the case was put that he was a foreman who went into the casting shop, and whilst he was in the casting shop on occasions, there would be carried out the following activities. Casting bowls and a feeding implement called a dossel for that bowl would have the asbestos linings of both smashed off, because as a refractory lining it breaks down over time. And then there would be mixing of asbestos in order to recreate the linings. He was visiting the casting shop on a regular basis. And on a number of occasions it was said not merely to deal with matters requiring negotiation between one part of the mill and another part, the casting shop.
Do we need all this detail?
Well, my lord, only if you are minded to follow the line of attack from the defendant respondents, that this was a very much higher level of exposure than we have in this case. And in fact, we say it contains many similarities, which is...
But this case isn't going to turn on comparing the facts of one case to another, except where it's clearly relevant to the principle of law formulated. That's why I'm just... But let's not spend... It's probably quicker for you to take us to the points than for us to argue about its relevance. So, carry on.
Well, in the light of what my lord has said, I can perhaps move, therefore, because I know my lord is aware of the conclusion of Miss Justice Buxton and Owen, that the review of the literature was that from the late 19th...
Well, that's what I'd like to see. Show us what are you trying to show us?
The bear with me 1 second.
I wasn't trying to stop you telling us everything you needed to
No,
tell us. You were just giving us a lot of detail about the facts.
No, exactly, but
Okay,
only insofar as it assists. If it's not assisted, then how will we do it?
okay.
So it's within the authorities bundle. Just finding my place again, forgive me. It is divider 8.
Yeah.
Thank you.
C. Swift is as she then was, isn't it?
Yes,
Yeah.
absolutely. Oh, yes, Mr. Justice Swift was a tribunal of really great expertise in this area.
Asbestos.
Yeah, without doubt. So page 294, if I may just direct the attention of the court to that. So 294 letter E sets out his summary over the page to what was known from the documents, and then at 296, letter E, he sets out what should have been within the minds of the employer. And it's between E and F. I find that a reasonably informed employer would have been aware from at least 1949 that care should be taken with asbestos, that he would have known from the middle 1950s that exposure to asbestos should be kept to its lowest possible level, and that from 1965 he should have known that there was a new and uncertain hazard. And then at page 314, B to F.
Which page? Sorry, I'm
So page 314, my lord, please.
314.
Letters B to F. And the important thing to be drawn, we respectfully submit from this, is that the 1965 watershed did not make any difference to Mr. Justice Buxton because of the findings that he'd made about the levels of exposure. It was the same both before and after 1965. Can I then turn, please, to the judgment of Mr. Mr. Machel in Jeremsey. In short order, the two deceased in that case had been engineers of various grades within ships that had been owned and occupied and operated by Shell tankers. They were employees of Shell. And the first point to note is at page 370, where the engineers he recorded, set out a league table of exposures. And they put dry sleep and third, but using the same descriptor as for stripping and mixing of asbestos. That was high airborne concentrations of visible dust. And it's with that in mind that we get at page 371. To the important part of his judgment. At the end of the first paragraph on the page there, my lord will see the sentence, the only guide to the intensity of exposure was the amount of visible dust liberated, inevitably accompanied by invisible dust. He then referred to a number of documents that he'd seen, including the photograph I've just shown this court under technical data note 35.
Yes, it may not matter. It doesn't say the only guide to the intensity of exposure was the presence of visible dust.
Yes.
The only guide to the intensity of exposure was the amount of visible dust.
Yes.
Yes, I see. Yep.
And then at the bottom of the next paragraph, the point of the latter was to demonstrate that the visible dust created by any activity is merely the tip of the iceberg, but it is accompanied by tiny particles invisible to the naked eye, which penetrate the alveoli and begin the process of pathological change. So with every cloud of visible dust, there is a miasma of invisible dust, which is the dust that actually does the damage.
But by the way, you said earlier, Mr. Machin, as he then was, did he subsequently become a judge?
No, I was referring to being a QC, now a KC.
I see.
A change I have not in any
Unless he
way.
was very long lived.
Yeah.
I think he's
No.
still the QC.
He's still a QC. Yeah. Now retired, in fact, just retired. To go back in the pages, but to advance in the analysis, Mr. Mitchell had to deal with a preliminary issue, and he does this at page 364. And he sets out on that page that Mr. Mackay QC, as he then was, of course, before Mr. Justice Mackay.
Okay, apart from this curiosity about Mr. Major, I think we can drop. It takes up too much time. Yeah.
I'm pushing the closed door. Had said, look, what you need to do is to take the average, because you cannot know as an employer from minute to minute to minute what the overall exposure will be. Whereas Mr. Allen said, no, what you need to do is to take the maximum exposure, because an employer cannot know ahead of time what the average is going to be. And Mr. Mitchell plumbed for the latter and set out that it was going to be his approach.
So far as asbestosis is concerned, that's wrong, isn't it? Because if you get the average, which takes in the maximum and the minimum, you'll get the total load, and it's the total load which determines whether or not you get asbestosis.
Not quite, with respect. What we know is that there is probably a threshold by which it can't happen. We know that the more you breathe in, the higher the risk moving towards an inevitability that you will develop it. But the Helsinki criteria, which I think my lord may have in mind, was only ever to answer the question, what level of exposure more than doubles the risk?
No, I wasn't thinking of that.
Oh, I'm so sorry.
I wasn't thinking of that. Asbestosis is dose related.
Yes.
Okay. If you've got intensity which goes like that, what you want to know is what the load that the person has inhaled has been. If you take the average of all exposures, i.e. you take what, instead of going up here and down here, you say this is how it works out in the long term. You get the same load.
Yeah, you might.
And so unless the fact that on a Tuesday morning you had a minute which was very intense increases your risk of asbestosis because it's intense, which I don't think is the position, I may be wrong, then what matters is the total load which you get from the average.
Yes, but that may be, forgive me, my lord, and forgive me for not understanding the question, that may be mixing apples and pears, because what my lord has in mind is, as I understand it, the biological cause of the outcome. The point about the spikes is that it's a signal that you should be doing something about the circumstances in which the employee finds themselves, which a more solid state might not, which is precisely the area we respectfully say.
I know, I haven't understood that. Why would a spike make it more obvious that you should be doing something than that an average would? Is it simply that evidently you won't notice an average? Yes, I see.
Yes. And we say that's where the judge misled himself, because he looked at things in terms of averages and thought, well, 1 to 2 fibre mils isn't that much. But he was missing the point that there are these spikes throughout the day.
The spike but a spike may trigger a duty to inquire, or in a time when you couldn't measure to measure. And it doesn't affect the question whether the particular person's exposure was liable to cause asbestosis or not.
Well, it would, on the evidence, if you recall a long time ago this morning, when I was setting out the concessions that Malone for Mr. Archer had won, one of those concessions was if there had been resort to expertise of the HMFI, in these circumstances, they would have said reduce dust. And once you reduce dust, you are reducing the risk and perhaps the severity of the outcome. The point is that, my lord, if I was to do a year with you and you exposed me to 1 unit, you cannot know whether I'm going to go off and be exposed to another 25 units elsewhere.
Different argument, I think, with respect.
Well, perhaps, but doesn't it go with respect towards foreseeability and why you avoid spikes? Whilst the employee is under your control, you do what you can to reduce his exposure or her exposure, because you don't know lots of things. What is the threshold for disease? what is their personal level of loading before they develop symptoms, or what are they going to do in the future to be further exposed, where your exposure may be the difference between them developing the disease or not.
But why would that be different with an average?
Well, as Lord Justice Underhill said, that it may be less obvious with an average that you're putting somebody in danger.
A different point. I respectfully suggest.
I mean, the risk is presumably the same whether there's zero exposure most of the time and a spike. And if the average is exactly the same.
It's triggering I can see how it triggers the obligation to make inquiries.
Yes.
But I don't actually see how it triggers the answer.
Because
Because the answer is dependent on the load. Forgive me.
no, not sorry, I interrupted you. Forgive me. Because as we went through with Merriweather and Price, the information is that we just don't know enough about low-level exposure and its effects. And this is why what the factory inspector, and I keep coming back to the factory inspector in 1938, said you reduce dust because you just don't know.
Then you're moving to a position of saying all exposure should have been stopped for everybody. Everybody.
Which is why we have to accommodate the existence of the watershed. And we do that because what you know after the watershed is something slightly different, my lord. You positively know after the watershed that trivial amounts can cause cancer. Whereas before the watershed, you don't know that.
But you're saying that even when you don't know, you have to avoid dust so far as practicable.
Yes.
And that's the position after the watershed. It's just now the risk that you thought might be there, which you had to guard against pre-1965, you now know is there. But the duty is just the same, isn't it?
Well,
If your argument is right.
we have to temper it with reality, because the risk is that you take all of this and you create an absolutist position, which is effectively how the defendants defend here. And we accommodate that by saying, no, we accept, as we read from the Tubical article before lunch, that there has to be some threshold. But the signal,
I don't know why you accept that. The logic of your position is that you should say there is no threshold.
because
Everything from 1930 or 1933 or 1938 onwards, it was clear that there might be a risk of serious illness even from low exposures.
yes,
And 1965 doesn't change anything.
well, I don't rely on it because I don't need to. I say that I got what I need, which is a lower
I'm
threshold.
just frightened of appearing to take a
Yes,
position that
absolutely.
would subvert what has become the orthodox view.
Yes, because I would like not to be the dangerous radical in this conversation. I would like to be the
well,
one
that's very
thought-
frank. And on the other hand, we'd already worked that out. So.
I wonder whether your spike point would work better with breach than it would with duty, in the sense that you say, well, this is something you could obviously do. You can see the dust. It's easy to reduce it, but that would be an aspect of what you have to do to having got the duty. Wouldn't it? It would be an aspect of what it's practical to do to reduce the risk.
My lord, yes, but of course, neither the existence of duty, the scope of the duty, breach and foreseeability can be seen as hermetically sealed silos. They each wrap round the other, and that's what Paris and Stepney tells us. When I ask myself the question, per law Reed, would a reasonable man ignore this, I'm entitled to take into account the severity of the outcome, and that feels like a question on causation. But actually, it's wrapped in what is the scope of the duty of care, which itself is wrapped around foreseeability. So that they tend to get round each other's necks, these issues.
I suppose you can say, imagine, sorry to slow you down, but
No, no.
I think we're near the heart of a part of this. Imagine a case where someone is employed by an employer for 20 years. And normally he has no exposure to asbestos at all.
Yes.
But on one day, he's told to go down into the basement and hack off a whole load of lagging, asbestos lagging. So he becomes, as it were, a conventional lagger for a day.
Yes.
And he gets mesothelioma. You would say, in those particular circumstances, don't worry about the average over 20 years. Don't even worry about the total load. That's a breach of duty on the day that he was required to behave like a lagger. Causation follows. and you would recover.
My lord, when does this take place? Before or after the watershed?
Before.
Before the watershed. We start from the proposition that what has to be foreseen is any pulmonary injury.
Is what?
Any pulmonary injury, not mesothelioma. I would have to show that on the day that I am acting as a lagger, my exposure is such that it gives rise to the foreseeable risk of injury. I say that would be breached if there was a cloud of dust.
For 1 day.
For 1 day. Because then, ex post facto, the control mechanism is when I develop my mesothelioma 30 years later, can I persuade a medic that 1 day down in the basement was sufficient to be the material contribution to what happens? But looked at prospectively on the day that I'm down there, it matters not what you necessarily know on the day alone, it's what you know about the future. And what you know about me, my lord, is you don't know what I'm going to be doing in the future, whether I'm going to be further exposed, so that your moiety is a material contribution to the outcome at the end.
Asbestosis.
Yes.
Okay. I think just thinking this through, the respondent's reply to this would be one day as a lagger on its own is not sufficient to give rise to a material risk of asbestosis. And therefore, if you're before the watershed, it's not enough on its own to give rise to a material risk of foreseeable risk of injury. And I think that might. We will go on thinking.
I wouldn't cavil particularly at that, because of course, in reality, that is not usually the way of these things.
Okay, but in that case, your spikes are purely a red flag.
Yes.
They don't actually tell you the answer. They're just a red flag that you should investigate.
They prevent you from doing nothing, even if all you do is go to your local HMFI, and the HMFI gives you awful advice. It's fine, carry on, don't worry about it, let that happen on a daily basis. You've done something. Whereas without the cloud dust, it may be the case that there is actually no breach of duty at all. That's not part of my case. My case is you need the cloud dust. But that, I hope, also explains why what we're saying is orthodoxy. Because in reality, if you've sent me down into the pipes for 1 day, you're probably sending me down reasonably regularly, and that is the way of these things in terms of how the evidence usually appears practically at trial.
Yeah. What else do you want from Jerems in the first instance?
Thank you. Simply to alert the court to where he makes findings as to the exposure, which is at 364 to 366 and 368. And we make the point, as I said this morning, that sweeping, having been described in the table by the engineers as being just the reference. Forgive me, I'm so sorry. Bear with me. Yeah, sorry, again, proving times relative to page 370. That sweeping gave rise to a high airborne concentration of visible dust.
Yes, we've already seen that.
Yes.
This was a case where on his findings, the exposures were of various kinds, one of which was sweeping.
Yes.
Yeah.
And he says at the top of page 372 that probably sweeping would have breached the standard in 1960. So insofar as the defendants wish to say, you have to see Jeremson in light of the facts, and it's a much higher level of exposure than this case, then the answer to the question is it may or may not be higher, but it isn't that much higher as to give rise to a gloss on what is found by the court in Jeremson in the court report. He then sets out at pages 382 to 384 that he follows
Buxton rather than Waterhouse.
Yeah.
Yeah.
And then finally, he deals with the loan furrow, rather in the same way that Miss Justice Mustin had done in Smith, at page 385, by saying that asking Shell to have done something, i.e. to take advice, and that advice would have led them to reduce the exposure, would not amount to ploughing a loan furrow, but is rather a criticism of the industry.
But where are you referring to?
At 385, my lord. So turning to Jeremson then in the Court of Appeal, and in order to assuage Mr. Archer, can I immediately make reference to paragraph 45? 45. This is at divider 12. And paragraph 45 is to be found at page 423. And one will see there that at paragraph 45, she sets out the tubercle article. Not in the detail, I admit, my lord, that I went through it this morning, but it was there.
But she's not relying on that, is she?
No, she's recording.
What she's getting from Merriweather is what was in the original.
Yes, but again, I'm not teasing my junior. It's important to note that he did take the learned judge below to paragraph 45. In respect of this morning's exchange, I was asked whether actually what one considers from the literature is a matter of law or not. I say the authority for that proposition is at paragraph 43 at the bottom of page 422.
You mean the reference to it being a matter for the court?
Yes.
But that's no different from if you have factual evidence and it's a matter for the court to decide what the findings should be.
Because the questions at hand are related to what was the scope of the duty and what amounted to foreseeable risk, and because it is related to documentation that is publicly available and will be cited case after case after case, it is perhaps I can say a matter at least of mixed factor law, but there is a hard edge to it. It's not just facts in each case. And then at the final couple of references, if I may, at 423, paragraph 45, which we've been to, but at the beginning of 45, she sets out what she took to be the headline message from the 1930 report, that prolonged intense exposure would inevitably lead to asbestosis. It must have been apparent to any careful reader that the effect of much lower levels of exposure was quite unknown.
Are we to take notice of the fact that Lady Justice Hale says the tubercle would not have been available to most European employers?
It is a fact. I can't gainsay it to the contrary. But it would have been available to HMFI. because Dr. Merriweather.
I mean, you don't need any of this because she does make a finding that was apparent from the Merriweather and Price anyway.
Yeah.
So,
Yeah.
Given the high incidence found outright, it would be quite unsafe for anyone to conclude what might be the safe level of exposure. Yeah.
And then finally, if I can turn to page 425 at paragraph 52. And here is the Rumsfeldian known unknown. I won't read it all out, but the first sentence is helpful. The point which impressed the judge was the certain knowledge that asbestos dust was dangerous, and the absence of any knowledge, and indeed any means of knowledge about what it constituted. Yeah, you have it. In terms of Maguire and Harlinger Wolf, I will be very brief indeed. That was also a power exposure case, as was Gunham Wallsend. So it's a case where there is exposure via overalls, and so the nexus between the employer and the victim is not employer-employee. The point to be raised from there is twofold.
Sorry, which case are we on now?
Maguire, please. That is divided. Second one. 14, divided 14.
Yeah.
All three judges refer to toxic substances in factory accidents. Lord Justice Mance and Lord Justice Longmore, although Lord Justice Mance gives the minority judgment overall as to the ratio, Lord Justice Mance and Lord Justice Longmore agree with each other that one cannot read the 1960 document as approbating lower exposure than the limit set out therein as being safe. And the references to that are paragraph 77 at page 541 and paragraph 90 at page 545. And then it's paragraph 91 and 92, Lord Justice Longmore held himself to be bound by the prediction Jeremson, which is to take the highest exposure to say that the duty on the employer is to reduce to the lowest level reasonably practicable, where a foreseeable risk of injury is created. And we say that if it was going to be limited in the way that the defendants say it was going to be limited, that is where there is much higher exposure than we have in a case before us here, that would have been made clear. And it is not, and that absence is of importance. Turning to Abraham and Ayerson, which is at divider 18. The simple submission here is that the exposure before Mrs. Justice Swift in that case was so much lower than the exposure in this case that whilst it must be right on its facts, it doesn't assist this court on the facts here. It would appear that the commentary on the 1960 documents, Toxic Dust in Factory Atmospheres, was not cited via Maguire to Mrs. Justice Swift. Something was made of this by Mr. Archer in the trial below. We don't particularly, we just simply say that the facts are very different. And then finally, in terms of the narrative, the final case that we seek to rely upon is Hawkes, and that's at divider 27. And we seek to rely upon it because in that case, although the ratio of the case is that there was no exposure to asbestos at all.
Sorry.
I'm so sorry.
Find time, give us time to get there.
I'm so sorry. Divider 27.
Yep.
The ratio is there was no exposure at all to asbestos.
So the ratio is what?
There was no exposure at all to asbestos. The lady in question had thought that she was stuffing asbestos mattresses for heated blankets, but in fact the learner just found that the interior was not stuffed with asbestos. It was a wire. Just sewing. So, yeah, forgive me, just sewing through the mattress. Yeah. where the judgment is of assistance is that we say that when he goes on to consider what the position would have been had he found the facts to the contrary, and that she was exposed to asbestos, he uses the creation of visible dust as the trigger, and that's at paragraphs 96, 97 through to 99 and 100. And my lord, I don't believe I need to take the court to.
So the whole of this passage is obiter.
It is obiter, yes, but it's a worked example.
Obiter, first instance,
Yes.
Deputy High Court Judge.
But if we like it, we'll adopt it.
We certainly liked it. But yes, please. We say it's a helpful template. It's no more, but it clearly isn't binding. We don't take the court's time up with Bussey. I said at the beginning I'd finished with the criticisms of the learned judge.
Yes.
My lord, in fact, the way that the submissions have gone, I think a lot of them have been.
Still, I think it wouldn't stop you from delivering a summary. I think you should.
I'm obliged. Thank you. He was wrong in our respectful submission to say that Jeremson, Maguire, and indeed Bussey did not require him to determine in this case that the scope of the duty was to reduce to the lowest level reasonably practicable the exposure, because there was no foreseeable risk created. The scope of the duty as enunciated in those cases is not predicated on there having been such a higher level of exposure in those cases that must suffuse what they say and be taken to be an unstated gloss upon it. He did not take into account the submission.
Is this your second point?
The second, forgive me, yes, so sorry. He did not take into account the submission that the creation of asbestos dust cloud was a sufficient trigger to cause the defendant to seek inquiry, and he should have. Third, in our respectful submission, he did not take into account the spike fully, and instead contented himself with looking at the averages. Fourth, he was wrong to say that the averages were far lower than those encountered in TDN 13, the 1970 standard he referred to. They were not.
Sorry, just could you give that one again, number 4?
Certainly. He was wrong, if he was going to use an average at all, to then characterise it as being a figure much lower than the quote 1970 standard, that being TDN 13. He was wrong.
We're on 5 now.
5, please, yes. To only consider toxic substances, the 1960 document, insofar as it referred to measurements, without taking into account that the vast bulk of that document seeks to interest itself in how you remove and reduce exposure before you get to counting. He then, next line is that he drew 2 inferences in particular against the interests of the claimant, and in the circumstances he was wrong to do this. Having found that he was a labourer, he then discounted the degree of sweeping that the labourer would have undertaken, with really no sufficient cause for doing so. And he was wrong to assume that the deceased was wrong when he asserted that he would have been standing in relative close proximity to the measure of a few feet when others were cutting. If my lords are with me in these averments, then we say that actually this is all a matter of proper inference, and that this court is in as good a position as the judge was, and can dispose of it without the need for a retrial. My lords, with gratitude for the time that's been allowed, I'll just turn my back.
Could I? before you sit down, can you just remind me why you say he's wrong to characterise the figure as much lower than the 1970 standard? I think you dealt with it this morning.
I did, because he found that the figure was 1 to 2 fibre mils as the exposure, and insofar as TDN 13, the 1970 standard, refers to figures as prosecution figures, not safety figures, the cutoff is 2 fibre mils. And I should have said that he was wrong to call this, when one stands back, light and intermittent exposure. It was substantial and intermittent, or heavy and intermittent. And that's not semantics. That is, it takes him down the wrong track. Others, thank you.
Yes, Mr. Kent.
Oh, may I just rearrange my...
Of course.
Lords, context is everything in this case. There is a danger of taking the ahistorical view, which is extreme in a case of this sort, going back 65 years or so. Mr. Phillips, the defendant's expert in Cuthbert, had, and I think I can just give you the reference at page 223 of Supplementary Bundle 1, a statistic, which is that at the time of his report, there were currently 4,500 asbestos-related deaths per annum. A terrible statistic, and one which of course makes all courts anxious when looking at allegations of breach of duty which have led to this awful fatal disease of mesothelioma. To do so critically, and it is very difficult to put aside the current context where so much more is known about it. First of all, some statistics which were in evidence before the court below. At page 90 of the first supplementary bundle in Cuthbert, having said that, I think it maybe the second. Yes, I'm sorry, it's the second supplement, the engineering bundle. You were looking at this a bit earlier, the annual report of the Chief Inspector of Factories for the year 1938. It's not a very good photocopy, and there is a better copy in my learned friends in the white literature bundle, but it's probably sufficient for these purposes. It was published in July 1939. And at page 90 are some statistics. Deaths from fibrosis of the lung, including silicosis and asbestosis, England and Wales, 1935 to 1938. A long list of activities in which exposure to silica might occur, might be experienced, with total silicosis deaths along the column 392, 365, 416, 430. Asbestosis with no breakdown of the activity, 15, 11, 13, 9. It's a very different picture in 1938. And the point is picked up again in the annual report of the Chief Inspector of Factories for 1958, which is at page 119 of the same bundle.
Page did you say, sorry?
Page 119. And the start of this document is page 112, so it's July 1959, it's published, so right at the end of the period that we're concerned with. And 119, two-thirds of the way down the page, under the heading asbestos, there is evidence of the existence of a relationship between asbestosis and lung cancer. The medical branch of the inspectorate collected particulars of 365 deaths which had come to their notice between 1954 and 1955, in which post-mortem examination confirmed the presence of asbestosis. In 65 of these, that is 17.8%, there was also lung cancer. So the
Which needn't,
Medic-
is that right? Which needn't be in the form of mesothelioma, is that right?
no, no, and mesothelioma wasn't even known about as a disease then. So this is an incidental finding of lung cancer. An excess proportion of those with asbestosis also had lung cancer. Obviously, lung cancer was a well-known hazard for people in any event. So many people smoked and so on. But the point I wish to make here is that in that period of 1924 to 1955, so about 30 years, 365 deaths, about 12 per annum.
But that's not an overall figure.
I'm sorry.
That's not an overall figure. Is it?
Well, it's all the post-mortem examination deaths which would come to the notice of the medical branch of the inspectorate. And given that there was, from 1931 at any rate, there was a compensation scheme in place, and it was a notifiable disease, then one would expect them to be aware of.
Notifiable disease from 1930 or 31, I think.
Yes.
And all they say is 365 deaths which had come to their notice.
Well, that is correct, but that we have some better statistics. If one goes to page 146 of the same bundle, which is a memorandum, it starts at page 140, a memorandum arising, a memorandum of the Senior Medical Inspectors Advisory Panel.
So which tab is this?
This is same bundle.
I know which tab.
Oh, I don't know.
Because the page number is often quite difficult to find.
52.
Sorry, 32.
32. Sorry, mine isn't 10. And this is a 1967 report of the Medical Advisory Panel. And at page 146, Table 5, asbestosis, Ministry of Social Security, diagnosed cases. One sees the cases being diagnosed between 1954 and 1965, and death certificates recording asbestosis.
I'm very sorry. It's so
What's the
small
point
that
you're-
Lord Justice Staunton would refuse to read it.
Yes, I'm not sure there's a
Which
better.
page are you looking at?
146 right-hand column,
Thank you.
and these would be certainly table 6 is death certificates recording asbestosis. So one presumes, therefore, that would capture a significant proportion of asbestosis cases, and they are then listed between males and
But
females.
what's your point?
Well, the period we are concerned with, we're talking about a far smaller scale of problem compared with the 4,500 deaths a year, which.
But so what?
Well, this is
It
part of
either is foreseeable and to an extent where precautions should be taken, or it shouldn't. The fact that there may be more deaths now, more deaths known about now, doesn't really advance the
Well,
argument, does it?
with respect, it does, because this is all part of the context. It's rather like Bolton and Stone, which is 6 times in the last 5 years the cricket ball has been knocked out of the ground and into the highway. And someone was on one occasion injured, might have been fatally injured.
Yeah, you're not suggesting employers didn't have a duty to protect their employees against asbestosis.
No, but the reason I'm referring to these statistics is a lead-in to the context in which advice is given in HMFI annual reports, often buried in a long report. And what we say is relative reassuring advice.
Well, when we get to that, that will be a good point. But I'm just not sure these statistics really help us. But
Well,
if you
I'll-
think they
I'll-
do, especially as they're actually quite intractable. I mean, you've made the very general point, which I think actually is the only point you're making, is the numbers are rather small. But
Relatively.
Well,
small
well,
compared to-
one reason for making this point is that one focuses, and this was a point made by Mr. Justice Mustall in Thompson. One tends to focus on the advice being given in relation to the matter before the court, whereas contractors and employers were inundated with paperwork and advice and so on relating to all aspects of health and safety. This is only one aspect, and so that is part of that context. But can we then turn to the legislation and guidance, because we have the Asbestos Industry Regulations 1931.
yeah,
And I don't need to take the court really to it in much detail, but I don't think you've actually been shown it. And it's in the authorities bundle at tab 32. Because this is clearly public domain material, even if it may have been, as it was, directed only to certain types of factory and not to such as my clients.
I wasn't keeping up. Where are we going to?
This is tab. It's tab. Wait, 32, I think.
In
In authorities bundle, my lord.
Page 1290.
1290. Yes. I got the wrong reference.
It's the third authority bundle. It's tab 32, but I'm not sure it is the reference.
Okay, in that case, I apologise. Yes, it is 32. It should be
Okay,
32.
well, that's fine. No, if that's what you, I thought you would take this as guidance, but if you'll take this as
No, this is the regulations
Yes,
themselves.
okay.
It's merely to point with such a point we made in the skeleton argument that the statutory instrument on page 1290 tells you what processes, what factories and workshops carrying out which processes are affected by these regulations, and they're listed. And then there's the proviso, provided that nothing in these regulations shall apply to any factory or workshop or part thereof in which the process of mixing of asbestos or repairing of insulating mattresses and so on is specified in 5, or any cleaning machinery or other plant in connection with any such process is carried on, so long as such processes of work or work is carried on occasionally only, and no person is employed therein for more than 8 hours in any week. So there's quite a significant carve-out in those regulations. And what they then provide for is various duties which effectively require precautions to be taken. The only requirement for a breathing apparatus, so the idea is to reduce the exposure at source, reduce the amount of dust produced into the factory workshop. Except for Regulation 10, a breathing apparatus should be provided for every person employed, A, in chambers containing loose asbestos, B, in cleaning dust settling or filtering chambers or apparatus, C, in cleaning the cylinders, and so on, and D, in filling, beating or levelling in the manufacture or repair of insulating mattresses. I'll come to why I'm focusing on that in a moment, but that was the scheme that was in place between 1931 and 1970, when the asbestos regulations 1969 replaced these regulations. My learned friend has made extensive reference to the Merriweather and Price report in 1930. That was a report to the Home Secretary, and we would submit the only relevance of that report, which is not insignificant, I accept, is that it tells you what those who are on the receiving end of it, namely principally the factory inspectorate, who I think in those days were under the aegis of the Home Department, what they would do. And of course, from the point of view of the employer, the contractor, they are not going to be looking at a 1930 report, which may or may not be available to them. I'm talking about an employer in the 1950s. They're going to be looking at the advice given by particularly the factory inspectorate and the Ministry of Labour, or whichever ministry it was that issued guidance from time to time. And my own friend made something about, I think to this extent, he was rather giving evidence about how the regulations were the result of a compromise following lobbying by asbestos interests. That may or may not be right, but of course it's not something which a contractor who's not involved in the asbestos industry could be aware of. It's never been suggested that Taylor Woodrow, they were a big employer, big construction work, building employer, never suggested they had some insight into the possibility that both the regulations and indeed the factory inspectorate had somehow been watered, the regulation been watered down, and the factory inspectorate had somehow been nobbled, to use a colloquialism. And that may explain why those statistics I've referred to may explain why the references to asbestos risks tend to be buried quite far into the lengthy annual reports of HM Factory Chief Inspector. The 1956 annual report issued in January 1958, so just during the period we're concerned with, is for this purpose, it's at the in the white core literature bundle is the easiest way to look at it.
Give us a second.
At page 77.
Sorry,
That's the start.
which bundle are you in? You're not in supplementary bundle 2. You're in.
Now, sorry, I'm now in the white appeal bundle, the core literature bundle, which I hope the court has in hard copy. But for this purpose, the PDF and the hard copy are have the same pages.
Oh, sorry, I've got a problem. I have got three Cuthbert bundles.
No, it's white. The other appeal.
Oh, sorry.
Wait, for convenience, we're using the
I was stupidly thinking of colour.
yes. It's their core literature.
Yeah,
Right?
okay. Sorry, my mistake.
Page 77 is the front page of
Yep.
the annual report for the year 1956, although not in fact presented until January 58. And we see that at page 81 of the bundle, and this is to make the point I've just made. This is 141 pages into a report, which is
This
has
is
a total
not your best point. I mean, really, it should be divided up into chapters, and it is. This happens to be chapter 15. So, anyway.
Well, my lord, insofar as the case is being put against us on the basis not of any explicit guidance or any, but of, as it were, hints from what is provided, then it's not irrelevant, we would submit, but it's not put at the forefront. But the point here is that the chapter 15 is
A
all
better point would be that you wouldn't expect Taylor Woodrow, say, to read the annual report of the Chief Inspector of Factories. If you would expect them to read it, then you'd expect them to read all of it,
well.
all the bits that are potentially relevant to the work they do. So,
It's always a point that's never really been resisted by defendants, which is that historically annual reports were part of the constructive knowledge of big employers.
Right.
And what that means in practice, I suppose, is that a big employer would have an occupational health or a medical advisor, and you have to put up with the fact that if they missed something in an annual report, then that's just too bad.
well, quite. I'm just one. The contents are interesting, but saying that people wouldn't have. You've either got to say that they wouldn't,
No, I didn't-
shouldn't have read them at all. But take your point about whether they're chapter 15 or page 141 is an empty.
No, I don't say they wouldn't have been read. I'm saying this is an illustration of the way in which the factory inspectorate were not considering this to be something that was so important it had to be flagged up in other ways. The chapter is all about the asbestos industry regulation, so strictly speaking, nothing in here applies to the activities of Taylor Woodrow.
Right.
However, at page 82 of the bundle, at the top of the page, the chief inspector says one very hazardous process to which the regulations do not always apply is the removal of old heat insulation lagging. The handling of this very dry and dusty material presents a serious health hazard, which is all the more serious because the work is often done in confined spaces. Much of this work is done in premises not subject to the Factories Act, and in any case the operation does not take long. The persons who do it are, however, regularly engaged in it and are constantly exposed to risk. That's the one comment that's made here about the risk in circumstances to which the 1931 regulations had no application. And it was, I think, cited in Jeremson, unsurprisingly in that case, because that was a case where there was a lot of removal of insulation lagging being the source of the dust to which the deceased were exposed in that case. Nothing, in fact, about construction work, and the point being made there, of course, is that it's the regularity of the engagement and the constant exposure to the risk on the part of those who are engaged in such activities, who may be outside the scope of the regulations and indeed outside the scope of the Factories Act. Then we, as I've said, and I should just say, it was Lady Justice Hale refers to that in Jeremson at paragraph 50, but clearly that was relevant to that case. In contrast, nothing here about construction work. We have what we say is that, and this is the point we're making in our skeleton argument, that applying Mr. Justice Swanwick's formulation in Stokes and Geskine Nettlefold, which has now been approved at the highest level, this is a case in which there is no evidence that the defendants, Taylor Woodrow, were doing anything other than following an established and recognised general practice. None was proffered. Even Mr. Cuthbert's own witness statement, we'll come to in a minute, tells us that he was engaged in similar work for another employer some 10 years later, with a similar complaint about lack of protection. So to go beyond the period with which this case is concerned, as has been done by my learned friend, and I make no complaint about that because it is necessary to put this into its historic context. We say this is a problem that the knowledge was evolving and developing over time, starting before 1930. No one has ever suggested that the fears that were developing about the risks from asbestos were greater at an earlier period than later. Sometimes you have a scare about a particular chemical, which turns out to be a false scare. And I suppose using Baker and Quantum in reverse, you might say the employer was in breach of duty when it was thought to be dangerous and can't pray and aid the later findings that it wasn't, if that happened to lead to injury. Here, by common consent, it's very clear there was a gradual development of concern, partly because of the increasing use of asbestos. One can dig out some statistics about the amount used. I think there are some of it is in some of the chief inspector's reports. Its use grew during the Second World War and continued to grow, particularly when companies like Cape invented these apparently very useful products like asbestolite, with which this case is concerned. So there was growing usage, and therefore there was a growing problem from that point of view alone. When we look at the point at which those in authority decided we better give some explicit guidance about it, what we say is that if, and I'll come to whether that's a correct assumption, if what was going on this with Mr. Cuthbert would not have been condemned under the later guidance, then the court could properly infer that no one, whether it's a factory inspector who is asked to advise or happens to be visiting the construction site, or an occupational health advisor or a medical advisor, would have suggested that some stricter standard should have been applied in the 1950s. I'll come back to the facts of the case in a moment, but we say that the 1960 booklet, which has been mentioned, but not, the court hasn't been taken to it in detail, it's probably easiest to look at it in the white core literature bundle at page 151, is itself instructive.
Okay. Which tab is it? Tab 9, is it?
Yeah.
It's tab 9. Yes, toxic substances. So this is, we see page 150 is the front page, and we see 151 what it's about, the booklets in this series. So it's very much for lay consumption. And we see halfway down the right-hand box, the box on the right-hand side of the page, halfway down the second paragraph, the series is designed to give information and advice about the best practices in the fields of safety, health and welfare. And on page 153, there's a section headed Permissible Concentrations. While systems of control should be as effective as it is.
Sorry, which page are you on?
153, right-hand column, last paragraph.
Yes, thank you.
While systems of control should be as effective as it is practicable to make them, it is desirable to have some guide to which the efficiency of the control measures can be related. And Malone Friends just, I think without taking you to it, has relied upon that as an encouragement to suppress dust and so on as far as possible. But then it says this, in the list at the end of this booklet, there are set out figures of maximum permissible concentrations of certain substances used in industry. For each substance, a figure of concentration in atmosphere is given. If this concentration is exceeded, further action is necessary to achieve satisfactory working conditions. So there's a bit of a mixed message there, because the word permissible is used, and satisfactory working conditions is an expression, a description of where you will be if you don't exceed those these limits. And at page 157, we have the limit for asbestos under mineral dusts. Asbestos is 177 parts per cc, which the learned judge took to be the equivalent in using a different measure of fibres per milliliter is not straightforward, but roughly 30 fibres per milliliter.
Roughly what?
30 fibres per milliliter. 30. And what we find somewhere in here is that these are time-weighted averages. Thank you. Yes, 154 left-hand column. The concentrations given are based on those formulated by the Committee on Threshold Limits to the American Conference of Governmental Industrial Hygienists, and also used by the International Labour Office as the basis of the papers published in its Model Code of Safety Regulations. The figures relate to average concentrations for a normal working day, based on the latest available information at the present time, subject to annual review and so on. My friend,
I don't quite know what that really means, average concentrations for a normal working day.
well, that's your time-weighted average across 8 hours, if it was an 8-hour day. So this is your.
What do you mean by time-weighted average?
Well, if you have a measuring device, which admittedly was not easy in those days, then you would you would say if you took half an hour that someone was carrying out a particular activity, they're exposed to X, you would divide the result by 16, 8-hour day, 16 half hours in the day, to arrive at the time-weighted daily average. So this is not an advice which talks about, in relation to asbestos, peak or ceiling limits, short-term values, much later, but such ideas are reproduced. Just one
total load over a day.
Yes, it's a daily.
Why is there a dispute? I think there is a dispute between you and the appellant about what 177 fibres per milliliter is.
Because I think it's because the method of measurement was. It's not just the dust in the air. Of course, dust will contain non-asbestos material. There had to then be some analysis through a microscope of what you're looking at, counting, and the system, the way of doing it. I I forget the name, is the membrane.
Yes.
There are different ways of doing it. So an exact equivalent for a standard was not always easy to speak of.
Have I understood that the appellant is contending for 2 to 5, and you are contending for 30?
No, it was.
On a like for like, or is that, have I misunderstood them?
I think it was common ground. You could call it 30
that
for these.
177 is 30.
Forgive me, I'm so sorry. There are two different standards. The 1960 document that Melanchthon is referring to
Yeah.
here, the authorities say it's somewhere between 5 and 30. The evidence in the case below was from the defence expert was it was 30. The document I was referring to was the 1970 document that the judge referred to, otherwise known as TDN 30, which set a standard of 2 for prosecution.
Yes, I'm coming to that. But it is correct that the parties below, in our case, proceeded on the basis that you could call this 30 fibres per millilitre.
Yeah, but that's after the watershed decade.
No, this time.
Yes, at this time.
1960.
So at this time it's 30, or conceivably 5 to 30, depending on where we go. At 1970, it's much lower on any view, but it's after the watershed.
It's after the watershed. Oddly enough, we debate whether it is actually lower, for reasons I'll come to when I come to TDN 13. But at this time, the point to note here is that the factory inspectorate obviously had the benefit of work done in the United States. And I think it's not in our case, but I think my own friend Mr. Platt in his case has evidence that was material available to the factory inspectorate right back in the early 1950s. So even though there may have been no published TLV, threshold limit value, the inspectorate probably had their own internal documents that told them they should follow the American 177 parts per cc. And so then we have, to move on, that's 1960. In 1965, which is at page 201, I think it's the same bundle. The booklet is reissued, and its name has changed to Dust and Fumes in Factory Atmospheres rather than Toxic Substances. But
What dates are 1965?
That's 1965. I think that it's slightly confusing because Mr. Phillips referred to a 1966 version. It maybe there was another impression. Maybe it's 66. Maybe it's 66.
So this is behind tab 12.
Yes, you say. And so at page, there's the front page. A lot of adverts we have to get through before we get to the introduction. And at page, I didn't read the number. 210, thank you. Yes, I see. The numbering seems to have been caught up in the text, but it says preface at the top left. And it says this: the threshold limit values refer to airborne concentrations of substances and represent conditions under which it is believed that nearly all workers may be repeatedly exposed day after day without adverse effect. Now, it is correct to say that, and this is part of the evolution of knowledge and guidance, that in this document, they go a bit further than the 1960 booklet and say that effectively there are no bright lines between being above and being below it.
Where does it say that?
Was the next paragraph: threshold limits should be used as guides in the control of health hazards, should not be regarded as fine lines between safe and dangerous concentrations. So it's saying two things really. The first paragraph is fairly comforting for any employer who keeps below the threshold limits, because nearly all workers may be repeatedly exposed day after day without adverse effect. But then the warning is, well, don't treat it as an absolutely bright line. But that's not the same as saying there is no low safe limit. That's a different point altogether. That's simply saying, as is obviously the case when you're dealing with the human response to a potential toxic substance, that everybody reacts in a different way. And then they have right hand.
Sorry, just before you take me further, it's not very blurred in the reproduction, but is the little headline at the very top, threshold limit values for 1964?
Yes, it looks like.
Okay,
Is that right?
correct.
Yes, it looks like that. Yes.
Thank you.
I didn't know why it's. And then the right-hand column under the heading Ceiling versus Time-Weighted Average Limits. Although the time-weighted average concentration provides the most satisfactory practical way of monitoring airborne agents for compliance with the limits, there are certain substances for which it is inappropriate. In the latter group are substances which are predominantly fast-acting and whose threshold limit is more appropriately based on this particular response.
I'm so sorry, I see, I found it, the very bottom of the right-hand column.
Well, no, it's the middle of the right-hand column. I've just read from the headings Ceiling versus time-weighted average.
Yes, I see, sorry.
And then it goes on, substances with this type of response are best controlled by a ceiling C limit that should not be exceeded. Implicit in these definitions that the manner of sampling to determine compliance with the limits for each group must differ. A single grab sample that is applicable to a C limit is not appropriate to the time-weighted limit. So it was an acknowledgement there that certain substances which have an acute effect, and it's no good just saying, well, as long as his weekly dose isn't too much, he can have a cup of cyanide at the beginning of the week. So there are ceiling limits, but as we shall see, no such notation appears against asbestos. There is no C value, there's no upper limit. And then again, on the next page, right-hand column, making the same point, third paragraph down, this limit for a normal workday does not apply to brief exposures at higher concentrations. Neither does it apply to those substances which may cause physiologic impairment at lower concentration. And the threshold limit for asbestos, I have to go several pages further on, page 218. Just to complicate matters, they've used a different metric. But under silicates, in the middle of the left-hand column, asbestos 5, but we see that that is 5 million particles per cubic foot. And further down, conversion factors, MPPCF times 35.3 equals million particles per cubic meter equals particles per cc. And in fact, if you multiply 5 by 35.3, you get to just about 177. So it's another way. That's merely an arithmetic change. It's not a question of measurement. That's just it's expressed in terms of million particles per cubic foot instead of particles per cc. So that is still 177, or roughly equivalent, we say, to 30 fibres per milliliter. And that's in 1966. And as I say, no C notation put against that.
It's Crown Copyright 1965.
Oh, it is 65. I was right about that. I think it may have been reissued in the next year. And we then have the next, chronologically, the next document of some interest is in 1968, which I think this may just be. I think it's in the. It is referred to by Mr. Phillips in his report, but the document itself is in the white reference literature bundle at hard copy page 408. I don't know how that's divided.
Page what?
408, my lord.
Okay.
Probably one of the earlier parts, and PDF 293.
448's bundle 1.
And sorry, the PDF number is.
And this is sufficient to look at the summary at the beginning.
I'm sorry, I haven't got up at all. We're
408 of the literature, the reference literature bundle in white, not the core literature bundle.
408.
408 in the hard copy. Yes.
Yeah.
293 if it's electronic.
Yes, I see. That looks
And
plausible.
This is a publication in the annual Annals of Occupational Hygiene, published in 1968. Hygiene standards for chrysotile asbestos dust. Now, although we are possibly not chrysotile, my learned friend rightly said that we now know that amosite, from which asbestox was made, is probably implicated more in mesothelioma than chrysotile. That certainly wasn't known at the time, and wouldn't have been known in 1968, and therefore at this point they were making a distinction between blue asbestos, chrysidolite, and the other forms, including amosite and chrysotile. It's quite a distinguished committee. It's a report of the Committee on Hygiene Standards. Some names that feature that become well known, including representatives of the asbestos importing and production industry, but including S.G. Luxon of the Ministry of Labour, Dr. Smither of the Asbestosis Research Council, and Dr. Wagner of the Pneumoconiosis Research Unit. He was the
I'm sure
man
all
who-
these names are well known to you, Mr.
Well, Wagner certainly, because he alerted the world to the mesothelioma risk in the early 1960s.
My recollection, which may be dull, is that it was sometimes suggested, perhaps uncharitably, that Mr. Smither was Dr. Smither was an employer's narc, if I can put
Yes.
it like that.
And Dr. Knox as well. I think that's certainly been said, but it wouldn't have been known or said at
But
the
it
time.
it doesn't apply to Luxon and Wagner.
No. And we hope some of the others, some of them are. But there's no suggestion
But
that
No,
this
I
sort
mean,
of
this is-
detail really doesn't matter, does it? I mean,
No,
this is the publication. So it's
just responding to my lord's.
sorry, it's
saying
my
they
fault.
weren't all immediately familiar with
My
it.
fault for
Sorry.
making the observation.
So under the summary and recommendations, 1, as long as there is any airborne chrysotile dust in the work environment, there may be some small risk to health. Nevertheless, it should be realised that exposure up to certain limits can be tolerated for a lifetime without incurring undue risks. 2, the committee believes
It's a
that
weasel word, isn't it? What's an undue risk?
well, yes, but then one is putting oneself
Non-negligible.
in the position of an employer who says, well, this is a body who's been reporting or involves the factory inspectorate, Ministry of Labour. And they must know what they're
Yeah,
talking about.
okay, no, fair enough.
And then 2, the committee believes that a proper and reasonable objective will be to reduce the risk of contracting asbestosis to 1% of those who have a lifetime's exposure to the dust. By asbestosis, this committee means the earliest demonstrable effects on the lung due to asbestos. It's probable that the risk of being affected to the extent of having such early clinical signs will be less than 1% for an accumulated exposure of 100 fibre years per cubic centimetre. That is, for example, a concentration of 2 fibres per cubic centimetre for 50 years, 4 fibres for 25 years, or 10 for 10 years. It is recommended that exposures which lie in certain ranges of dustiness be designated by categories according to the following scheme. Then dust category in the left-hand column, right-hand column, concentration averaged over 3 months, fibres per cubic centimetre. So this isn't even simply an 8-hour working day. This is an average over 3 months. And for example, you only get above low when you get 2 fibres per cubic centimetre. And
So is that the daily average, averaged over 3 months? So you take the measurements for 3 months, and then the figure in the right-hand column is your average daily
Yes.
figure.
so you would need to be someone who's working for 3 months. They have
Yeah.
highs and lows, but it
And
all
your average is
it all
to
averages
be
out.
medium, your 2 to 10 per day.
Yes. And then I think it's probably sufficient for these purposes over the page, number 5.5, when it is necessary to work intermittently in a high dust area, an approved mask should be worn, provided that the concentration is no more than 50 fibres per cubic centimetre, and the mask has been shown by test to be a good fit. Should the concentration exceed 50 fibres, a higher standard of respiratory protection should be provided. That is some sort of air-fed mask. So that's 50, which is well above even the high level, which starts at 10 fibres per millilitre.
But this is well, maybe I don't know. It says intermittently in a high dust area. Does that mean potentially a peak?
Well, it's interesting.
I mean,
Yes, I suppose it is. That must be, because otherwise it would be impossible to apply that guidance. That's right.
So if you had from time to time to go into an area where there was a concentration over 10, I suppose.
It's over. Well,
High is 10.
Is it a high dust area first? Well, then is it over 50? Which would be I respectfully agree, but that must be a snapshot.
But it, even below 50, you're supposed to have a mask.
Above 10.
So assuming above 10.
Yes, absolutely right. Yes, it's 50 is the respirator, and above 10 is the mask. Yes, so that's 1968, which of course is 10 years or more over beyond the period we're concerned with.
Did it say anything about mesothelioma?
It does.
It's a long report.
Page 414, but it basically says we don't know.
Yes.
But your point, I think, is that this is guidance about asbestosis 10 years after the event, which means that as regards the only known risk 10 years previously, i.e. asbestosis, this is some retrospective guide to what would be acceptable then.
We say that. It's rather odd to worry about asbestosis given the mesothelioma scare, which has now hit the headlines, although it may be that it was still in its early days of in terms of understanding what the implications were, because there was still an issue about whether even the mesothelioma risk was one that was manageable, because it's even though it
We
may
don't
be
need to get into that for the purpose in which you're using it.
it's just an oddity that they're concentrating on asbestosis there. And then we have there was a proposal to reduce the 30 fibre per millilitre measure to 12, and that's I think we can just see that in Mr. Phillips's report at the end. He summarises it, and this is in supplementary bundle 1 in Cuthbert. This is on page 241. He refers to dust and fumes in factory atmospheres. So that's
Which page did you say?
241 of the supplementary bundle, the first supplementary bundle in Cuthbert.
Yes, I have it.
One of the appendices to Mr. Phillips' report. He's introducing the 1968 version of the document we've been looking at, now called Dust and Fumes in Factory Atmospheres. But he says over the page 242 at paragraph A2.8.7, within the 1968 list, asbestos, all types, is listed as a mineral dust and is again assigned a limit value of 5 million particles per cubic foot. That's the same as the 177 particles per cc. A notice of intended change was also declared, which stated that the proposed TLV for asbestos all types would be asbestos 12 fibres per milliliter greater than 5 microns in length, or 2 million particles per cubic foot. That's offering the two ways of measuring. One is by the membrane.
Sorry, something's wrong with the punctuation there, hasn't there? There should be closed brackets after the word magnification. Is that right?
Yes, yes. Or two as counted by the standard impinger. That reflects the fact that there are different ways of measuring, and you can pick up more fibres by one method than another. So that was the notice of intended change, but it was overtaken by events, because we then had the asbestos regulations, 1969, and can I just take the court to that? Those regulations, briefly. They are in tab 45 of the authorities bundle. Page 1334, and they made in May 1969 and came into force on the 14th of May 1970. And they did away with the old 1931 regulations, which only applied to certain factories and processes. There's an interesting reference here under Regulation 2 interpretation on the next page. Regulation 2.3. References in these regulations to asbestos dust shall be taken to be references to dust consisting of or containing asbestos to such an extent as is liable to cause danger to the health of employed persons. Rather strange that in 1969 they were providing a definition which itself contained an assumption that there was a level of asbestos dust which would not be liable to cause danger to employed persons. Not a terribly helpful statement for anyone reading these regulations, and indeed in the regulations themselves, no threshold limits are set out. There are a number of obligations on the employer. More relevantly, is that at the same time, guidance was issued as to the attitude of the enforcement authority, the factory inspectorate, and that is TDN 13, which we have to go to the best version is in the white core literature bundle, page 300.
Which tab is that?
16, thank you. It starts at page 300. Standards for asbestos dust concentration for use with the asbestos regulations, 1969, technical data note 13. And on the page 301, first paragraph, in this note, guidance is given on how HM inspectors of factories will interpret the expression dust consisting of or containing asbestos to such an extent as is liable to cause danger to the health of employed persons, thereby quoting directly from that interpretation section of the regulations. Then they provide themselves with a get-out clause by saying that only the courts can give binding decisions in these matters, although quite how the courts are supposed to say anything that the inspectorate doesn't know isn't clear. Then they have a section for chrysotile, amosite, and fibrous safe light. And a later section for chrysidolite, but we're concerned with this first section. A, where the average concentration of asbestos dust over any 10-minute sampling period is less than 2 fibres per cc, and they also give it in micrograms per cubic metre. HM Factory Inspector will not seek to enforce the substantive provisions of the regulations, in particular regulations 7 and 8. Where the concentration is 2 fibres per cc or more, but not more than 12 fibres per cc, further sampling over a 4-hour period will be carried out to determine whether the average concentration of asbestos dust still exceeds 2 fibres per cc. So it's a sort of triage process that's the factory inspectorate requires to be carried out. So it's not to emphasise, it's not a snapshot, save that the triage process does start off with a 10-minute sampling. For practical purposes, obviously, occupiers of factories can hardly just have measuring devices out there for hours. They have to do some localised sampling. And it's only a lead-in. If you're below 2, you needn't do anything more. If you're above 2, then you should carry out a 4-hour sampling period, and then you see whether it exceeds 2 over 4 hours. So, when my learned friend says rightly that 2 fibres per cc comes in with TDN 13, it does the qualification that it's again a time-weighted average, this time over 4 hours. Then B, where the average concentration over a 4-hour sampling period is 2 fibres or more, the extent to which HM Factory Inspector will require the standard of control to be improved will depend upon the amount by which it exceeds 2 fibres and the duration of exposure. And then C, where the average concentration over any 10-minute period exceeds 12 fibres per cc, inspectors will normally seek to confirm or otherwise the accuracy of the test by means of a further sample before taking action to enforce regulation 7 or 8, whichever is appropriate. So it is evolving, and that it might be said that 12 then becomes a sort of ceiling value at that point, because that's not a time-weighted average. We're very much at this point in the hands of the discretion of the factory inspectorate as to what they do. But there's a very clear message that 2 is all right, below 2 rather is all right, even over 4 hours. Above 2, well, you may or may not get enforcement, an enforcement notice from the factory inspectorate or stern advice, but it depends how far above, and indeed the duration of exposure. So that's what you have in 2.
How do we equate the 2 back to 177? Do we multiply by 35 again?
Well, it's if we take 30 as correct, then it's 1/15 of what was taken in this case to be the effect of the previous guidance. 1/15.
It's 2 instead of 30.
Yes. Although, but 12 then features in a rather different manner as a sort of peak value, or a short-term value. So that's the guidance in 1970. So that's between 12 and 15 years after the period we're concerned with. Even 7 years or so after the scare about mesothelioma is well established. And while we're in this bundle, it's of some interest to go to TDN 35, which is guidance in 1972. This is not about levels as opposed to how you control the dust.
It's the next document in the bundle.
It's the next document, yes, follows on. And so it's 19 I think the date is by common consent, it's 1972. I don't know where we find the date, I think possibly right at the end. And there's a long introductions, and in fact, there's something said about the visibility of dust. Page 306, the foot of the left-hand column, a comparison of figure 7 with figures 8 and 9 illustrates the fact that the dust pictures show dust which is normally invisible in ordinary lighting conditions. Figure 7 is from that part of a cinema autograph film which was taken under ordinary lighting and shows the man emptying a bag into a hood. But no dust is visible. Figures 8 and 9 were taken immediately after figure 7 on the same hood with the same man, but with a beam of light. A point that was made by Mr. Phillips. The visibility of dust is very much dependent on the specific conditions and lighting conditions. A ray of light will show you far more than a gloomy day. What is of interest, though, is that if one goes through this document, there are a number of pages with photographs. 313. No, that's not a good one because it's not clear enough to see what he's doing. if one goes to page 318, there is a router cutting asbestos board with an exhaust system operating. This system barely controls the dust, but seems to keep it just below the breathing level. There's a man clearly without any mask or respirator. No comment made about that, as far as one can see in the document.
Well, but the point is,
It keeps it below the breathing
it keeps it below the breathing
Just,
level.
yes. But if one then goes to 324 and 325, there are more images where certainly the lower photographs on both of those pages do seem to suggest, they certainly do show visible dust, but it doesn't look as though it's far away from the breathing zone of the individual who is wearing no mask and no breathing apparatus. And we have finally on page 332 and 333, we have photographs presumably of someone from the factory inspectorate holding out a meter into the dust, which is being tipped into a 40-gallon drum, insulating material, and there are three images of the same thing. Now, of course, reducing the production of dust at source is important, but going back to our case, Mr. Cuthbert was working on a construction site. He was, we'll come back to the facts of his case in a moment, he was exposed indirectly as a bystander and more directly when sweeping. It is a curiosity, it's more than a curiosity, that in 1972, when these images were taken, in a publication of the factory inspectorate, a technical data note, there are images which show that even with visible dust, whether or not immediately in the breathing zone, no one suggests that there's something wrong with people working without breathing apparatus or without masks. And that, the reason for taking the court to that is to underline how we say very anachronistic this approach is. Clearly, today, one would be horrified at those images. No official publication, asbestos is banned, but even before it was banned in the 1980s, or later than that, I think, no one would suggest that that is an acceptable practice because of the risks. But that's what that's the public domain material.
Just, I follow the general point, but as to the pictures you were showing us, we're looking at, say, figures 33 and 35.
Yes.
And they're referred to on page 312. It's not obvious that they're saying it's good.
Well, certainly some of them, the point is made that the exhaust appliance isn't working very well. There's some leakage.
So it's a failure of the ventilating system.
Yes.
I mean, that doesn't sound as though it's approving of the method.
No, but how curious to have photographs that don't also say you can't rely on these exhaust appliances. You shouldn't even have someone anywhere near it if there's a risk of escape. The simple point is that the intelligent and concerned employer seeing this in 1972 is, I'm afraid, given the wrong message about this. And yet, Taylor Woodrow are supposed to have taken a completely different attitude and plied their own furrow, to use Mr. Justice's lustful phrase, some 17 years earlier, long before the malignancy risk was known.
When you say a reasonably competent employer, you appreciated that much lower exposures to asbestos could give rise to a foreseeable risk of injury.
When do I say? Oh, what we say that it's only after the well, it's really the guidance that's given towards the end of the 1960s, because that alerts. Query whether an employer should be reading the Times and reading the article of the Sunday Times about the mesothelioma problem in October 1965, which is sometimes taken as the watershed, or whether you give them a bit longer.
Rather the issue in Bussey.
Yes, but that is once you get to that point, it's an oddity that actually the courts have approached the matter on the basis that a responsible employer will take steps which the guidance I've just shown you doesn't seem to be acknowledging. Even the factory inspector at Dentsu, or the HSE, as they became Dentsu, caught up with their own knowledge. But it illustrates the difficulty of applying standards of a much later period.
Well, until we set up either a public inquiry or a test case for all time specifically set up to resolve this issue, you're going to have the possibility of actions like these, arguing to push what I'm going to call the date of knowledge forwards or backwards. And it may be case specific, not just on the evidence that the parties choose to call, but on the knowledge of the employer.
Well, certainly, Baker and Quantum says that you have better knowledge, you've got to act on it.
Yes, but for example, CAPE, a claim against CAPE, may raise different questions.
Yes, absolutely. Well, but that's partly because they were, it depends on the period, maybe it said they knew about the risk of malignancy from low doses at an earlier date, but
that's
no one suggests that.
No, I'm not suggesting it for Taylor Woodrow. I'm not putting Taylor Woodrow into the CAPE category. But it's demonstrated by cases like Chandler and CAPE and the extension of the duty of care to parent companies.
And what we say is the full syllogism in this case is the assertion, well, asbestos is dangerous, therefore you should reduce it to the lowest possible level. It's not, that's not how it works. The law of tort, as my Lord the Vice President said in Bussey, it's a two-stage test. What is reasonably foreseeable? And then, if some risk is reasonably foreseeable, then what steps should you take to deal with that risk? Not, well, it's dangerous in a sort of abstract sense and it wouldn't have cost much to buy a mask, so what's the problem, for example? That's not how the test in negligence works.
Can I also mention something else, which is, on one reading of Jeremson, it's very close to applying what is generally known as the precautionary principle of, if there is a possibility of risk and you don't know what it is, you've got to exclude it altogether. But that, at the moment, my provisional view is that is not the approach to the common law.
Yes. Well, the answer to that was given by Lord Justice Longmore in Maguire when he gave the example of passive smoking, because my own friend's argument would seem to present this problem, that every occupier of offices, every manager of a pub or promoter of a railway who allowed smoking to take place, where there were those who were not smoking in the vicinity, would now be held to be liable, because it was known that smoking was dangerous in one sense, dangerous for the people who did it. And later it becomes apparent that there's a secondary effect. That can't be right, nor can it be right, which is the effect of Malone and Friends' argument, that throughout the 1950s and the 1960s, we say the logic is that every employer or occupier or contractor who allowed who didn't take any steps to minimise asbestos exposure, whatever the levels they understood them to be, would have been committing criminal offences under the Factories Act or the Construction Regulations or the Office Shops and Railway Premises Act. And all that can be said is the factory inspector were rather lax about enforcing them. That's the effect of it.
I'm not sure I agree with that, because you've specifically gone to the Factories Act rather than into the common law.
Well,
And the Factories Act have their own, Section 47 has its own special wording.
yes, although in this particular case, as the judge recorded, the parties agreed that there wasn't any difference for these purposes between the equivalent of Section 47 in the construction regulations
Yeah,
and common law negligence. So logically, there's a breach because one assumes that the factory, the legislation was at least as strict as the common law, and maybe may have been stricter. There are lots of chemicals which can be described in an abstract sense as dangerous. Botulinum toxin is apparently one of the most poisonous whatever it is, compounds there is, and yet cosmetic surgeons inject it into people's faces. Now, safely, no doubt, we hope, but if in 20 years' time it turns out that that was giving rise to some terrible outcome, it would be wrong to say that the person who engaged in that activity is liable, because in a general sense it's a dangerous chemical. It's always got to be specific to the circumstances. One can't talk about it in the abstract. Lord Porter in Bolton and Stone, who talks about reasonable foreseeability, says you can't talk about the thing being dangerous in some sense. He said if that was right, motor cars are dangerous, but you don't reduce driving to the absolute minimum. There are lots of activities, sporting activities, which are dangerous. You have to focus on the unacceptable risks that flow from your activity, based upon your concept of reasonable foreseeability. And incidentally, while my learned friends rely upon dicta in Kufos and Zarnico, and it was only dicta because it was a contract case, not a tort case, Lady Justice Hale in Jeremson makes it very clear that the question of foreseeability is determined by Mr. Justice Swanwick's test in Stokes and Guest-Keen metal folds. And we say that's the correct approach. And it is not, therefore, enough to say there is a theoretical risk, you could have done something about it. You're not required. It's not enough to say that is the position, particularly where there is no evidence that anyone else behaves differently. And there really was no evidence that building contractors were doing anything in relation to those sawing or working on asbestos boards, or those working in the vicinity at the time.
If you wanted to rely on a general practice, that would be for you to show, rather than them to disprove, wouldn't it? Because
Well,
you would be saying, I mean, the way it goes is you can rely on a general practice unless it's obviously bad, or it should have triggered you at least to ask questions.
yes,
The starting point, if you want to rely on the general practice in the construction industry, you need to prove it, surely.
well, we would say it may be an evidential burden, but there's not a
Yeah, but it may be an evidential burden, but the burden's on you.
Well, there was a little bit of reference to that in the transcript. The judge asked Mr. Phillips about that, and I could take you to that now. It's in the supplementary bundle 1 at page 63.
How many?
63, supplementary bundle 1. But it starts at 63, and then there's another reference. Middle of the page, this is in fact the judge asking Mr. Phillips, middle of the page. So the answer to the question, no, you would not have expected a building company to have taken measures to protect a carpenter from asbestos dust emanating from the cutting of asbestos board or asbestos cement. He's talking about the carpenters. Answer, it's a really difficult question, then it's inaudible.
So I'm behind.
Page 63 of bundle,
What is it,
supplementary bundle 1 in Cuthbert.
Yes, thank you. Where in the left-hand margins? Oh, I see.
D,
yes.
middle of the page. So this is the judge asking a question. You would not have expected the building company to take measures to protect the carpenter. Answer: it's a really difficult question. Well, if you were telling me you cannot answer, so be it. I think the answer is closer to no rather than yes, and it would depend on the extent and scale of the cutting, inaudible, and whether it was inaudible, a number of factors. For a carpenter, probably the only means of protecting, at the time, would have been through use of respiratory protection. Now, he's talking about the carpenters, and incidentally, of course, respiratory protection would have provided no protection to Mr. Cuthbert unless he was also given it. Then at page 67, again, the judge at letter C, it's really an intervention because my learned friend Miss Foster was objecting to some questions of Mr. Phillips is going beyond the scope of expertise. The top of the page, in fact, the judge points out that the chief inspector of factories was reporting to Parliament. And then at letter C, Judge Freedman, what Dr. Phillips can say and has said is that his understanding of what was happening in the construction industry at the time was that absent intense prolonged exposure, warnings and instruction were not being given and dust was not being suppressed. Is that right? Answer: that inaudible is my understanding. Now, whether or not Mr. Phillips was qualified to give that opinion, that's the state of the evidence before the judge. We would say, in fact, it's an inference. One doesn't need an expert or even a lay witness to deal with this, because you can draw an inference from the surrounding circumstances and all the documents, some of which I've taken the court to, as to what advice, if any, was being given by the factory inspectorate.
It's rather surprising, though, that there clearly was a considerable awareness back to the 30s of the dangers of asbestos in certain circumstances, and leads to regulations in the context of lagging and so on.
Yes.
But when asbestos products like Asbestolux, no doubt there were others, were developed, I forget what the evidence is, but sometime I think post-war,
I think it was. Yeah.
nobody was thinking, we all know that asbestos is dangerous in certain circumstances. Will it be dangerous in these circumstances? I.e., if the boards become friable or are cut. So there was no evidence about that either way. Is that right?
No, well, the experts really agreed as to what the literature and standards were around the time. I mean, as far
Yes,
as
but as you've demonstrated, the literature and standards are not really directed to the construction industry, and more specifically to the use of asbestos products in the construction industry. And I'm just raising a query. I'm not sure where it goes, but that it's a bit surprising that when asbestos products come to be widely used in the construction industry, but in ways which are not quite the same as the ones which were causing concern in the 1930s, nobody said, well, will this cause a problem?
well, that's right, and one of the my Lord Justice Stuart-Smith referred to the case of Chandler, which was a case against Cape, one of the big manufacturers, based upon their better knowledge of these risks and their failure really to deal with exactly the problem my Lord has mentioned, which is you're introducing this new product to the market. But
What were the facts in a sentence? What were the facts in Cape? What was the
they
what was the asbestos
He worked for
generated?
a subsidiary.
Yeah, he wasn't directly employed, but there was a nexus, a duty of care was owed to someone who was handling these products.
Yes, but which products as well?
Oh, well, they were not. I think it was asbestos cement.
I see,
variety of
but similar to asbestos.
where there was a risk of
Precisely.
exposure through them being cut or broken or and so on.
Precisely.
So there is no doubt that, that there was a very slow reaction to what should have been obvious, at any rate to the manufacturers, which is that we are introducing another source of potential exposure to asbestos outside the asbestos factories,
Yes.
and also the laggers and so on. The problem with lagging was that it was more dangerous to remove when it was dry than applying when it was wet, and so it's only when
Yes, well, that's a different point. But yeah, I mean, that the broad point is that following the development of knowledge of the risks of asbestos in what I might call the old-fashioned and conventional uses, whatever those might be,
Yeah.
new products were developed.
yes.
But there was no guidance about those, no literature as far as we can see.
Well, there's some
For quite a
literature
while.
from the manufacturers. There is, which is unhelpful, and in the sense, that it's in retrospect reassuring. Miss Conroy, in her own report, also in the first supplementary bundle, has an illustration.
Yes, I saw all those.
Well,
But
there's
they
one.
didn't really address the question of safety, except by not saying that it's unsafe. Is that right?
Well, it's
Marvellous.
yeah.
Yes, exactly.
They do say a lot about it, but in her report, at page 134 of the first supplementary bundle, she reproduces an asbestolox advert from Do It Yourself magazine in July 1958.
Yes, no. Well, that's not, I didn't actually
And that shows
focus
someone
on that, but
sawing the product with no protection. And then at 186, I think this would be of the second bundle, bundle 2.
The whole stack of them.
yes, no, I've seen
Yeah,
it.
this is an asbestolux production. We don't actually have a date on it, but it seems to be either late 1950s or early 60s, and it's a promotional thing. But you have page 184 onwards. You have men working with asbestos, and 186 in particular, sawing the asbestolux, the very thing that the carpenters were doing in Mr. Cuthbert's.
Well, I'm not sure where my intervention goes, but I mean,
Well,
But-
so you have a
I mean-
combination of the manufacturers apparently saying, which is a splendid product, and this is how you deal with it, and conspicuously nothing in it from HMFI to the contrary. The only examples given in that report we looked at in 1959, I think, was the reference to removing dry lagging. No reference to the construction industry at all. No reference to these new products.
yeah.
So that would be a moment at which I think I'd probably come to the end of a section of my submissions.
Well, I see the time. We could go on to 4:30 if necessary, and I would if I thought there was problems about how much longer are you going to be?
Well,
You haven't tasted the case law yet.
I haven't, but I can be fairly quick with that because
The same problem about meaningless adjectives. How long do you think you will be using
Well, an hour, I
metrics
think,
such
probably.
as minutes?
an hour.
An hour tomorrow morning. Now,
Well, I can be shorter than that.
Mr. Steinberg and Mr. Platt have heard how it's going. How much of your ground has been covered?
My lord, I don't intend to recover the ground that my learned friends spent on the literature
Quite.
or on the law.
So frankly, you will be pretty short. And your case is factually much more straightforward.
It is, and also our point is narrower as well.
Well, that's really well, yes.
Lord, I will have to act as a sweeper, I suspect. I've got some issues with what Mr. Rawlinson has said about the literature, and I will have to
Yes, I see.
amongst it. But the fundamental issue in our case may be quite straightforward, which is a matter of fact.
Yes, quite. It's 4:25 anyway. We may as well stop. And the real question is, I think the answer is, I don't, from what I've heard, see any need to sit any earlier than 10:30. But because I think we will speed up.
I could probably do it in 3/4 of an hour. And I don't need to. I could take in his
Okay,
robots.
one thing
and scale it.
speaking for myself, and I haven't discussed this with my lords, there are some specific factual points made about the judge's judgment. No evidence for him to make the findings that he did. And you need to cover those.
I will.
Yeah. Very well. 10:30.